Welcome to immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to this special edition webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. My name is GB Satusa, and I will be your host for today's important discussion: H-1B transfers with pending green card applications, preserving priority dates, and navigating AC21 provisions. Now, an H-1B worker changing jobs while a green card is pending can raise important questions about maintaining status and protecting long-term immigration goals. Rules surrounding portability, priority dates, and AC21 provisions can create both opportunities and risks during employment transitions. Knowing how these rules work and how to navigate them properly is essential for individuals who want to maintain stability while advancing their careers. To help us break this down, we are honored to be joined by Mia Giacomazzi, Esquire, an experienced immigration attorney who advises professionals and employees on employment-based immigration strategies, including H-1B portability and green card processes. Attorney Giacomazzi, thank you for joining us today for this important discussion.
Thank you, Blessing. How are you today?
Well, thank you, attorney. Now, before we begin, a quick reminder to our audience: immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you are joining us from Facebook, YouTube, LinkedIn, or any other platform, welcome. Please subscribe and share this session with anyone who you may think may benefit from understanding H-1B transfers and green card portability. Now let's get into it. Attorney Giacomazzi, can you explain how H-1B portability works in the context of a pending green card process?
Sure. So it's a very good question. It's one that we're addressing with quite a bit of frequency with our employees and our employers both. And before I answer that question, what I want to do is set the stage a little bit, because we have these terms here, and I think that if we first give a definition to the terms, then it will help us go along the way. So H-1B visa is a non-immigrant visa. So it has a start date and it has an end date. In order to apply for an H-1B visa, a person must have a job opportunity that requires at least a bachelor's degree. So it is a professional job opportunity. And then there is a lottery. And then if selected into the lottery, then you get your H-1B visa. H-1B visa is traditionally only valid for up to 6 years. And then that's the end of your H-1B. Okay. The green card is a informal name for a permanent residence card or an immigrant visa. So that is someone who is expected to live and work in the United States permanently. That's why it's called permanent residence. Okay. Back in the day when they gave out the cards, they were green. They're not green anymore, but now it's still called the green card. All right. People in H-1B status can also, in parallel, have a green card process going. So these are very distinct processes, but they're usually going on at the same time for people in H-1B status. And there are two ways that people in H-1B status can qualify for permanent residency. One would be through an employer-sponsored um, um, immigrant visa. And that process is sort of a three-step process where you do what's called a perm with the DOL, and then you apply for an I-140 with USCIS that will reserve an immigrant visa for you. And then at the end of it, then you apply for your adjustment of status to adjust from your H-1B to your green card. Okay. So we've kind of have that. One of the big differences or distinctions between the H-1B and the green card is that the H-1B is the position that the person has right now. So that's the job that they have. When you hire someone on H-1B, that is describing the job that you will be hired to do as soon as that H-1 application is approved. But the green card process is it's a long process. It takes at minimum 2 or 3 years. And that is for the job that you will do in the future. Once you actually get the green card after you pass all of the other. I need to step back. I forgot to say the second way in which an H-1B person can get qualify for an immigrant visa is by being a self-petitioner. And they can do an EB2 and IW petition, and then they skip the perm and go straight to I-140. Okay. What does this have to do with portability, and why are we talking? What are we talking about here today? So, several years ago, the Congress passed something called the American Competitiveness in the 21st Century Act, or what we call AC21. And AC21 affects H-1B people in a number of ways. One of them is that it allows H-1B visa holders to port themselves from one H-1B employer to another one. So to change employers. And they do not have to actually they can start working for the new employer even before the approval begins, so long as it's a non-frivolous application to change employer. That new work can begin as soon as the application is received by USCIS and not after it's approved. So that was one of the things that was important. And then there is another provision separately in AC21 that is the adjustment portability. And this allows someone who is on the final stage of someone who has an H-1B visa, but is in the final stage of their green card process. So they've got the perm, or now they have the approved I-140. They have applied for the adjustment of status by submitting the I-45. But their I-45 now has been pending for at least 180 days or 6 months. In that case, the H-1B holder can, in fact, change employers at that time. And so they are not tied to the employer who sponsored them for the perm and apply for the I-140 once their I-45 or their adjustment of status is pending for at least 180 days or 6 months, provided that they find someone new to sponsor them, and that new person submits documentation to USCIS by way of an I-45 supplement J, and the new job offer is in the same or similar occupational classification, which we'll talk about in a little bit. But that's the idea, is that it allows people options. And there was a reason for it, because actually when the AC21 was approved, there is such a backlog of people who are on H-1B statuses. I mean, I think there was something that came out that said that Indian nationals on H-1B would have to wait 100 years in order to get their green card approved. And so it became the system changed from having someone who was on the H-1B for 6 years to be able within those 6 years get their green card, to someone who um had to, after those 6 years. Another thing that AC21 did was it allowed someone, after their H-1B, the 6 years of the H-1B status was up, to extend it in increments of either 1 or 3 years, so long as the green card process is has reached a certain point, whether the perm is going or the I-140 has been approved, that sort of thing.
Yeah.
And so, and the reason for it was because there were, uh, people who were very important employees to businesses in the United States, and who have very important contributions to the U.S. Economy and society, but they just were on H-1B status for possibly decades. And so it allows them freedom to move jobs without being stuck with one job for 100 years.
Yeah.
So that's how it works in the context. So say someone is a software engineer, they were sponsored originally by company A, they had the ability to file the 485. The 485, or the adjustment of status, is pending for 7 months. If that person gets a new offer from company B, and it's a similar or the same type of job opportunity that was in the perm and the I-140, she can accept that offer, file an H-1B transfer with company B, and then start working at company B right away. And that green card application, that same I-45, keeps pending, and she doesn't have to reapply for a new 485.
Mm.
That's
So,
the process in adjust in
yeah,
yeah.
in that context. Now, attorney, how are priority dates preserved when an employee moves to a new employer?
Okay, so what's a priority date? The priority date is the date of the time either that you're able to file your adjustment of status, or when your adjustment of status will actually be processed and reviewed by someone at USCIS, and then either you're invited to an interview and it's approved or whatever, but it will now then be in process. So the earlier the priority date, the better. And every month, the priority dates change. There's something called the visa bulletin. So everyone looks at the visa bulletin and says, okay, where's my priority date? All right. Under AC21, there was the rule that if an I-140 is approved and has been approved for at least 180 days, then the priority date is locked in and the priority date becomes fully portable. What does that mean? That means that after that time, the priority date is attached to the person, the employee, and no longer in the hands of the employer. So again, it gives flexibility to the employee. And so the priority date is usually set on the date that the perm is filed, or at the date that the I-140 is filed for those who don't require the perm. And you can think of it as like a timestamp, or if you take a number and then wait in line, but it's a very long line. Okay, but that priority date belongs to the person. And so even if the original employer later withdraws the I-140, or even if the employee leaves that employer that sponsored the employee, So long as the I-140 was approved for 180 days or longer for more than 6 months, then it's preserved and the employee can always rely upon that. So that was a major protection for employees that was added by the AC21.
Okay.
And additionally, even if the employee goes to a new job, okay, and then that new employer wants to hire them for something different that's not substantially similar, so they file a new perm for a new job and they get a new I-140 with a new priority date.
Yeah.
The old or the oldest first priority
Yeah.
date can still be recaptured.
Okay.
So you can file an adjustment with this new job opportunity that you have, but using your original oldest priority date. So that's another example of the way in which you can preserve your priority date when you leave the original employer, or even if you move into a different um, type of position or a different type of a profession,
Yeah.
and then get sponsored by a new employer, you can still um, rely upon and then file your adjustment of status using that earliest original date.
Okay. All right. Now, attorney, at what stage in the green card process do more job flexibility options become available?
Okay, so, you know, putting it all sort of together with what we talked about in the process, right? So while the perm is going, that's the employer committing to sponsorship. There's no flexibility. Once the I-140 is approved, okay, um, you can move, but remember that there is some issues because the I-140 can also be revoked or withdrawn from the employer, right? But if it stays for um, at least 180 days, then you can keep your priority date. All right. So I-140 approved and locked in, but you haven't been able to file your adjustment yet. All right, there is some flexibility, but it's limited. You can transfer your H-1B to a new employer, um, but if it's a different position, your employer, well, yeah, if you haven't been able to file your 485 yet, you can switch to a new employer, but the new employer typically is going to also have to start a new perm and a new I-140 process for you. The good news being that you can still keep and recapture your old priority date.
Okay.
Once you've gone beyond that, though, once the adjustment of status is filed and you have, in fact, and it's been pending, well, let's go back. Once you file your 485, your adjustment of status, at the same time, you can apply for what's called an employment authorization document, or EAD. This will allow you to work freely now without dependence on one single employer. So once you get that EAD, you now have flexibility to work with other people and your employment is not tied to the employer who has sponsored you. Okay. And then once the 45 is pending for at least 180 days, that's the key milestone. And in that case, AC21 portability kicks in and the worker can change employers or positions without jeopardizing that pending I-485, as long as the new role is in the same or similar occupational classification. And if it's not, then, then that new employer can also start a new perm and get a new I-140 and then present that I-140 in with the pending I-45. Um, and then you still recapture, rely on your original priority date.
Yeah.
And then beyond the 6 years of the H-1B, which we touched upon a little bit, AC21, you have some flexibility in that it enables H-1B extensions past the 6-year cap, and then you can continue to extend your 6 years, your H-1B indefinitely until
Yeah.
you have the availability to file the 485. Um, and so then you do also have sort of that flexibility.
All right. Now, Tony, you've touched on the AC21 for a bit. What are the requirements for a new job to be considered same or similar under AC21
So
portability
this
rules?
is definitely a very fact intensive um, process, and USCIS says that they do it like um, with the totality of the circumstances. What I'd like to do is first look at the job duties themselves and make a comparison to say, okay, what are the job duties that you were originally sponsored for in the perm and approved on the I-140, and what are these new job duties, and then you start comparing them. If they've got, 70% overlap, then it's looking pretty good. But if it's, something that is totally different, then you won't be able to rely on it. USCIS, the first thing it'll do is look at the what's called the SOC code, or the standard occupational classification code, and that is a code that's assigned to each job opportunity that the USDOL thinks that there is in the United States. Okay. And then for that job duty, under that code, it will give a list of tasks. So we can look at the list of duties and then also the SOC code. And if the SOC code is in the same sort of duties, in the same family, so the offered position and then the new one is in the same family, or if the actual duties are similar, or if the skills are similar, or if the educational requirements are similar, then it will more than likely be approved by USCIS. So they really do look into the details. It's not just a matter of, oh, what's the job title? What's the salary? And another thing to consider, which is very important, is that the job opportunity does not need to be identical. So it's not this rigid, like it has to be the same title and it has to be the same SOC code. In fact, it's really more about, and I also want to say that sometimes that's not expected, because if you got this I-140 and this perm approved 5 years ago, and now you have actually 5 more years of work experience, then it would be reasonable that you now are eligible for, if your perm was filed as a software engineer and now your job title is senior software engineer, well, okay, that's clearly the same or similar, job or job opportunity, but it also reflects that the person has more seniority in the position based on the real life work experience that they have, and that makes sense. But what probably wouldn't work is where, you've got a perm and it's for a mechanical engineer, but you want to work, switch to a product marketing manager, for example. In this case, obviously, totally different SOC code, different duties, different skill set. Education might be similar, but in different backgrounds, that sort of a thing. So in this case, it is a very fact specific review. And I always say, before accepting an offer, reach out to your attorney and then have them go through this analysis, compare the SOC codes side by side, um, go through the job duties side by side, the skills, the requirements, and all of that, and then get sort of an opinion about whether the new role aligns with the original perm, or whether um, you're going to have to ask that new employer to start up a new perm process for you.
Yeah. Now, what risks should employees be aware of when changing employers while their green card application is pending?
So, putting it all together here, right? The
Yeah.
one risk is leaving the employer before the 100, um, before the I-140. has been approved, and for 180 days. So that's one thing. And then there's also the 180-day cliff of leaving the employer before the 485 has been pending for 180 days.
Okay.
Because if the 485 has been pending for less than 180 days and you leave your employer, likely USCIS will consider that an abandonment of that green card application. The end. And so this is truly the single most important timing threshold, is that once the 485 um, is submitted to USCIS, then you are committed to staying with the employer for at least 180 days. Another thing is, when changing employers while the application is pending is just, what we just spoke about, is to ensure that there is no same or similar mismatch with the new job opportunity that the new employer is offering to you. Um, there's also risks with RFEs or interview questions, um, because when you go through a perm process, the expectation is that you will work for a certain employer. And if you are jumping employers, there may be questions about that and your interest in wanting to remain a resident, or uh, whether your state of mind when you went into the perm process with the original employer. There may be issues again with the SOC codes and the new job opportunity to ensure or confirm that it is the same job offer, it's the same classification, and that sort of a thing.
Yeah.
um,
Mm.
Other things to consider for H-1B is, to um, be aware of H-1B status gaps. So there is a 60-day grace period. If you leave one employer, you have 60 days in which to get a new job opportunity with a new employer and file a new position. And so you need to be aware that you do have the 60-day grace period, but we should also be aware that a couple of months back, some folks who left their H-1B employment were actually getting notices to appear and were putting in removal proceedings even during that 60-day grace period. And so while there is the 60-day grace period, I would recommend to be very careful and thoughtful about avoiding being put in that position, and to actually sort of always have an H-1B application, a new one submitted if at all possible for you before leaving the one, your the H-1B job opportunity that you have been approved for by USCIS.
Yeah. Now, what happens if the original employer withdraws the I-140 petition after the employee has already changed jobs?
So if the I-140 has been approved and, for more than 180 days, then you're protected. The employee is protected, and the approval remains valid for purposes of H-1B extensions and priority date retention, regardless of whether the employer revokes it. The worker keeps the priority date, and then if the I-485 is pending, that continues to process.
Okay.
There might be a risky scenario if the I-140 is approved for fewer than 180 days, which we already talked about. And I do want to say, though, that there is a fraud exception to this. So if USCIS suspects that the original I-140 was revoked due to fraud or willful misrepresentation, then none of the protections apply. And so an employer could, make those sorts of assertions towards you. And if the
Mm.
USCIS wants to review that, then there could be trouble. So, you know, um, those are some issues that I would, and tips that might come up, but rarely do.
Yeah. Now, looking ahead, what practical steps can H-1B workers take to protect their status during the job transitions?
So my first recommendation or comment is to build your personal file. So a lot of times H-1B, okay, so when an attorney is filing an H-1B, an employee needs to understand that it is the employer who the attorney is representing. Unless there is actually a dual representation agreement between the employee and the employer, it is the employer who is having the legal representation by the attorney. Um, so if an employee down the line wants to go to the attorney to say, hey, I want to, can I have receipts or copies or approval notices or this or that, because the employer doesn't want to give that to them, or if there is a breakdown between the employer and employee relationship, unless there's dual representation, the employee themselves will not have access to that lawyer. They will have to go get their own legal representation, let's say. So I always suggest to employees, build your personal file, keep personal copies of all the immigration filings, the I-129 petitions, I-140 receipts, approval notices, 45 receipt notices, all your cards, keep everything. Don't rely on your employer or the attorney to have those things. Especially if you expect to be in this process for a very long time, because you may go through 6 employers, or some employers may go out of business or move offshore. And in all of those circumstances, or you may, find yourself in a mass layoff. There were 10,000 people laid off from Oracle today. I'm sure a lot of them were H-1B people. So in that case, you cannot rely on your employer to say, oh, can I also have my immigration file, please? No, you should always take care. Make this a part-time job for yourself to always keep those documents. Also, get your EAD early. So if you have the opportunity to apply for a 485, apply for the EAD. It used to be like free to apply for the EAD, but now you have to pay. I think it's like $785 for for the filing fee, and so all of a sudden people don't want to apply for EADs, but if you and then just stay on the H-1B. But if you get your EAD, then again, you are free in case something happens. You're still free to work in the United States in case there is an employer-employee relationship breakdown, and you need to find employment elsewhere. And then you don't have to rely on that 60-day grace period and find a new employer in 2 months. Monitor your priority date. Consult an immigration attorney before making a move. Negotiate immigration support with the new employer. And if they don't know anything about immigration, find your own attorney and then introduce them to the employer. A lot of times when I start representing businesses for H-1Bs, it's actually the employees themselves who have found me and then introduced me to their employer, and then I represent them both. And consider premium processing when you can for the H-1B transfer. Because last year, some of the applications that were filed like in June were not approved until November, December. And so that was very concerning for some people.
Yeah.
So those are my takeaways, I guess you could say, from that.
Thank you so much, Attorney, for those eye-opening insights. It's been truly an interesting session so far. Now, for everyone watching, this discussion about H-1B transfers and pending green card applications is not meant to create panic, but to provide a bit of clarity about how job changes can affect immigration status. Now, careful planning and understanding the rules can help individuals make informed decisions during career transitions. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage with participating attorneys. We're also proud to share that ImmigrationQuestion.com is Triple B accredited and ISO certified. This is reflecting our commitment to transparency, accountability, community education, and security. Now, Attorney Giacomazzi, based on your your practice experience, how does immigrationquestion.com help immigrants and immigration attorneys such as yourself?
Yeah, I mean, I find it great that it's a free resource for immigrants to be able to ask their questions, get them answered, to watch webinars such as this, to get some free advice from, legal experts. And then when they are ready to make a move, then to be connected with someone who, is an attorney who's been vetted and can provide some good legal advice.
Thank you. Now, before we move into our live Q&A session, let's tackle this important question. What is one common misconception that H-1B workers have about changing employers while a green card application is pending that you believe should be clarified?
Well, I think one misconception is that it really goes back to having the same or similar job opportunity. One of the misconception would be that the perm position is equal to the H-1B position, and it's not. They are completely separate things. So when you are starting the perm process or starting the green card process from the very beginning, it should be a future or forward thinking thing so that you can grow into that position, so that the jobs that you are getting at the time that you apply for the adjustment of status is now the same or similar to the job that you would be getting in the future, and not the one that you have right now. That is the biggest sort of misconception or issue that I see, is actually at the inception of the case.
Okay. If you're just joining us, we've been speaking with attorney Mia Giacomazzi on H-1B transfers with pending green card applications, preserving priority dates, and navigating AC21 provisions. We are now moving into our live Q&A session. This is your opportunity to ask general questions and hear educational insight from a licensed immigration attorney. Drop those questions in the live chat or call us live at 516-703-3483, and we'll take as many as time permits.
All right. Give us some good questions.
Yeah. Okay, first one. If I change employer while my green card is still processing, will I lose my priority date?
Okay, so the answer is it depends. If you change your employer before the green card application has been pending for 180 days, then your whole 485 will be gone. It will be deemed abandoned. But so first and foremost, I would wait to change employment until at least 6 months. Okay, that's number one. Number two is, even if that happened, though, if your new employer wanted to start over again and put you on a new perm, and then you got through that perm and got it approved, and then you got a new I-140 filed and you filed a new 485, you could go back and recapture the first priority date. So there's a couple of things to think about there, but ultimately speaking, you wouldn't lose the priority date if your 45 is still pending at the, and you transfer to a job that is the same or similar job opportunity as the one that is in the pending 485. But even if you change to something totally different and get a new I-140, you can still rely on that original priority date, so long as the I-140 was approved more than 180 days.
Okay. All right.
What else do we have here?
When can I safely transfer my H-1B without affecting my green card process?
So Generally speaking, at least, it depends on where you are in the process, but you can shift for after the 485 has been approved for at least 180 days, then you can shift. However, that new employer will have to start a new green card process for you, but then you'd be able to recapture the original priority date of the original I-140 with that one employer. If you've already filed your 485, then you cannot change employers for 180 days. But after that 180 days, you can safely transfer the H-1B to a new employer and have that new employer file the 485 supplement J to your pending 485, so long as the same or similar job opportunity as the approved 40 I-140.
All right. Why are some people waiting many years even after the I-140 is approved?
Okay, so this goes back to priority date, but essentially this is what it is. The US Congress has a certain limited number of immigrant visas that they give out every year. And those visas are broken down into categories. So you have the family categories and you have the employment categories. The family categories are like, okay, the wives and the spouses and children of green card holders, or the brothers and sisters of citizens, or the parents of green card holders. So there's a whole bunch of different categories there. Then with the employment, you also have your EB2, EB3, EB1, EB5. And so there's a certain number within each one of those categories, okay, that can be given out per year. In addition to that, there's another rule that says that only a certain percentage of that number of visas for that specific type or category of the immigrant visas, no more than a certain percent, can be given to one country in order to protect the diversity of who is coming in. So, for example, let's say there's 20,000 immigrant visas given each year in the EB3 category. Okay, they'll say, oh, we can't give more than 2% of those 20,000 to people from India or people from China. And so it creates a different weighting line for people from certain countries that have just more applications under each category than others.
Okay.
But that's why it's that there's just a limited number of visas that are allowed to be granted each year, and this is by Congress's act. And so USCIS can only give a certain number, and there's more applications every year than the number of visas that are available. And so you start waiting in a line, and that's what happens.
Yeah, yeah. Now, recent reports indicate that TSA staffing challenges have led to longer wait times at airports, potentially affecting travelers across the United States. Attorney, for H-1B workers and other visa holders who may need to travel while managing job transitions or pending applications, how should they plan in light of these delays? And what precautions should they take to avoid complications during travel?
So, yeah, definitely. This is something that is on everybody's mind. So let's sort of address it directly. Um, the background is that there's a partial DHS shutdown that began about 6 weeks ago. And about 50,000 TSA officers are working without pay or not working at all. Many TSA officers have resigned, and there is issues in most of the major airports in the United States right now, including Houston, Atlanta, and others, where the wait times in going through immigration and security are just really long, anywhere from 2 to 4 hours in length at this point. And in order to sort of take TSA's place, President Trump has asked ICE to have a presence at the airport, which is, having ICE agents deployed at 14 major airports to assist with security operations, including verifying traveler IDs, is understandably creating some anxiety among immigrant, non-immigrant travelers. So what is my advice? Arrive early, much earlier than normal. If you would go, I would say at least 3 hours for domestic travel, 4 more for international travel. There is an app called the My TSA app, and it does show real-time wait times at specific airport and terminals. It's free and surprisingly useful for planning. So check that out before you leave your house or planning to travel. Always carry all of your documents. So have your EAD, your valid visa stamp, your 797 approval notices, your passport, your domestic, even for domestic travel, have absolutely everything with you. Maybe you won't need them, but having them removes any ambiguity as to your status. And then know your rights and stay calm. So for domestic travel, for example, you're not required to answer any questions related to your immigrant status. Cooperating is great and is required from everyone, but you don't have to answer that. So if a TSA officer, for example, asks to see your ID and your boarding pass, that's standard procedure. That's fine. But if someone comes up and asks about your visa status while you're in a security line, you can politely decline. And, just knowing that difference sort of helps.
Yeah.
And, for those who were just selected in the H-1B process, I would say the lottery results just came out this week. I would say definitely check with an attorney before traveling, because there are issues related to travel with H-1B at the moment. But that is very case specific. But I mean, the bottom line is get information from reliable sources, go to uscis.gov, talk to your immigration attorney, official airline communications, etc. But don't get your news from social media. It does seem scary, but fear spreads faster than facts on WhatsApp groups and Twitter is what I have found. So, if you have a valid immigration status, you have every right to travel. Be prepared, have your documentation, and that should turn anxiety, into confidence.
Yeah.
And happy travels. It's a holiday weekend.
Yeah, indeed. Thank you to everyone who joined us for this special edition webinar. And thank you, Attorney Giacomazzi, for sharing your knowledge and practical guidance with us today.
It's my pleasure. Thanks for having me, Blessing.
You can always visit immigrationquestion.com to ask immigration-related questions and stay informed about policy updates and register for upcoming live events. If you missed any part of today's important discussion, the replay will be available on Spotify soon. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Friday at our next live session. Until then, stay informed, stay prepared, and stay connected. Bye-bye.
Bye-bye.